K. French.
And Mr. French, what is your date of birth?
7/1973.
All right. You are here this evening because you were arrested on charges of aggravated assault, a Class 4 felony. I did find probable cause for that.
But that's not true. We were holding her, trying to pray for her.
Okay.
And just calming her down, and then that's where I'm.
All right, so I am basing my probable cause finding upon the information contained in the Form 4. Like I said, I am finding probable cause. I am appointing you an attorney. And I do acknowledge that you, like everybody else, has their own side of the story. So I am appointing you an attorney, and you can tell all of those things to your attorney.
Okay.
I am setting a hearing on September 9th at 8:30 and September 11th at 8:30 in the downtown Maricopa County Superior Court.
What days are those?
It's September 9th and September 11th. It is a Tuesday and a Thursday.
Okay, because I start a new job Friday, tomorrow, or next day. So.
Okay. So I am setting a secured appearance bond in your case in the amount of $25,000. In the event you are able to post that bond and secure your release, you would be subject to certain release conditions to include electronic monitoring. You may not return to the scene of the alleged crime or have any contact with the alleged victim. You may not reside at the same location as any alleged victim or go to the alleged victim's residence, even if you are an owner or renter of the residence. If you presently reside with any alleged victim, you must find an alternative residence. You can arrange for one civil standby with your local law enforcement to collect any essential belongings. Now, I understand that you and the alleged victim share a common minor child. Is that correct?
Yeah.
Okay. So I did put a provision in here that you may contact the alleged victim only by email or text messaging and only regarding issues directly involving the parenting of your common minor children, with no harassment to occur even if the messages are related to parenting. You may have in-person contact with the alleged victim only to accomplish exchanges of the child by prior arrangement through email or text message. Okay? All right, all that.
So, am I being released today, or am I going to jail?
No, I
was told different things from everybody because it's my first offense, and she's dropping the charges. She even told the detective that she was not pressing charges. She wanted me out of there. And since our fight, we've reconciled. I'm going to all kinds of men's groups, and even before that, and she's told me before that she was like, I need you to pursue me. I need you to come after me. Like, come to me and pray for me when I get mad and go, and go ballistic. And so I thought I was supposed to do that, and I'm holding her. I wasn't hitting her. I didn't smack her. I didn't hurt her or anything like that. I'm just holding her, trying to calm her down.
And I understand, and that is your position. Again, that's not consistent with what I'm seeing in the Form 4. I am setting.
Domestic violence things start off with, I wasn't smacking her or hitting her or anything. I was just kind of holding her and putting her in her place. And hell if I know how she busted her lip. That's just how it works.
Secured appearance bond in your matter in the amount of $25,000. In the event you are able to post that bond and secure your release, then you would be subject to the release conditions. You can work with a bonding company to get that bond posted, and officers will have that information for you, okay? All right, go ahead, step to the left. Officers have your paperwork. DeAndre Douglas, please. Just had to walk across.
All right, everybody. Welcome to American Courts. Thank you guys for coming out. I hadn't seen a lot of you in a long time. Thank you so much for remembering. Kathy sent me this video, so thank you, Kathy, with Court Vibes. You're awesome. I have been so busy at work. It's hard for me to even keep up with the court, much less record anything or make anything worth watching. Some of the other creators have been doing some good jobs keeping it up, and hell, AI's been taking it over. So if you guys keep wanting to watch AI, y'all keep watching it. If y'all want to watch real creators, Court Vibes, People in Court, Miss Fields, Old Squishy Gardner, there's a handful of ones out there that really have humans behind them. Go watch them, especially Court Vibes. Back to this video. Thank you so much, Kathy, for sending me this.
All right, sir, you are here because you were arrested yesterday on charges of resisting arrest, using physical force, a Class 6 felony, disorderly conduct, fighting, a Class 1 misdemeanor, and obstructing a public highway or thoroughfare, a Class 2 misdemeanor. I did find probable cause for those. Based upon the information that you provided to pretrial services, I am finding that you are not indigent for purposes of appointing you an attorney, so I am not appointing you an attorney this afternoon.
Well, I'm unemployed at the moment.
Well, according to the information you gave to pretrial services, you've been employed at the same place for 3 years.
Yeah, I was telling them I work on an app that I haven't been able to work on because I don't have a car anymore.
Okay. All right, so you're currently unemployed?
Yeah.
Okay. All right, so based upon that, I'm going to go ahead. Thank you for providing me with better and updated information. Based upon the information you provided, I am going to go ahead this evening and appoint you an attorney. I am setting hearings on September...
And Your Honor, I'd like to find out one main thing, if at all possible.
Yes, sir.
With regards to your finding of probable cause, after reading the probable cause statement that they made, none of the stuff that they said even happened.
Okay. So I am appointing you an attorney, and you can talk to your attorney about your position. I am setting hearings on September 9th at 8:30 and September 11th at 8:30, both in the downtown Maricopa County Superior Court. In your new matter, I am setting a secured appearance bond in the amount of $5,000. Now,
$5,000?
You are also here because you are currently on probation in CR 2024-110245. In that matter, hold on. Your new charges would constitute an alleged Term 1 violation of your existing probation. In your probation matter, I am appointing you an attorney, and I am setting hearings on September 10th at 8:30 in the downtown Maricopa County Superior Court. In your probation case, I am setting a secured appearance bond in the amount of $250. In the event you are able to post your bonds and secure your release, I am reminding you, because you are on probation, you would need to contact your probation officer within 72 hours. All right, we do need to reprint your paperwork to reflect the attorney's.
I have one quick question, Your Honor.
If you didn't save your signature for number 6.
Yes, ma'am.
I have one quick question, Your Honor.
Yes, sir.
Because this resisting arrest thing appears to be a very serious charge. Okay? And I can't imagine what they said in the probable cause statement as to how I resisted arrest. Because I made no further movements or did anything. They just rushed up to me and slammed me to the ground and started, hog-tying me. For no reason. I didn't even resist or do anything or work combative or nothing.
Okay.
And so I do think the bond is a little steep in this matter, and I don't even really think there was a finding of probable cause, but I have no idea what they told you. So I'm just wondering, if all possible, if the bond could be reduced for those reasons, because I swear to you, none of these things happened.
Okay, and I understand, and again, I have heard your argument, and I have looked at the Form 4, and based on the information in the Form 4, which is that you use physical force to resist attempts to take you into custody, I am finding probable cause.
No, when they say physical force, that's so vague.
Okay. All right, and you can share all of this information with your attorney, who I have, and I have appointed one for you. If you go ahead, step to the left, officers have your paperwork for you.
Over here, sir.
Thank you, Your Honor. This is some bullshit, man. This is some bullshit if I ever heard, man.
All right, I love how the professional the judges are, because, in my world, someone saying something like this is... Hold on, let me check. Eileen's in here. Yep. If someone were to say something bad like that, I couldn't, I'd end up punishing them, but then again, I'm petty, so, this judge. You're right, Dan, the video and audio does not match. I will get with the judge and tell her to correct this before we do it again. So we're just going to work through it tonight. We're going to do what we can with it. Again, thank you everybody for coming out here. I got Judge Oakley, some Thurston County small claim stuff about something about a car engine. I stole a video from people in court. I mean, I recorded a cool court video, definitely not stolen from people in court. And then I've got one from Judge Simpson. Let's do the last one here. I've been told the last one's good.
All right, Mr. Goins, go ahead, state your name for the record.
Bradley James Goins, birthday of 9/14/1990.
Thank you. And you are here this evening because Maricopa County Superior Court issued a warrant for your arrest on a direct complaint matter. That direct complaint alleges that on or about February 5th of 2025, you committed the offense of sale or transportation of dangerous drugs, a Class 2 felony. In that matter?
Never have I got a sales charge. I never got, so whoever that is, I lost my ID, and this is on my dead little brother, that I know for a fact. The last time I was in court was for a trespassing charge, and I seen the judge, and I got out. And then, literally, that was my last. There was no way, and I'm telling you, I put that on my little brother that passed away, that's no way that's me. I've never had a drug charge in my life. I don't sell drugs. I know for a fact. So whoever, and if you can look up the picture that they make that person take, whoever that is, on that day that whoever that got caught, I did not go to jail for anything like that, ever. I know for a fact.
Officers, has NCSO confirmed that this is Bradley Goins?
Yep, he has his fingerprints and digital VIN fingerprints by APIS.
Thank you. All right, sir. So I'm going to find for purposes of this IA hearing that you are Bradley Goins and you are the Bradley Goins who had that direct complaint issued, that direct complaint arrest warrant issued. To the extent that you believe that this was somebody else, identity is a defense, and I'm going to go ahead and appoint you an attorney, and you can talk to your attorney about that, okay?
But listen, though, if you look at the last time I was arrested, right? All right, so, and I got released because I was on trespassing. If that was from February 5th, I would have never been let out. I would have never been let out.
Okay. All right, so I'm going to go ahead and set two hearings in your case. The first
I'm
one.
not even going to court, and I'm just going to sue every day y'all keep me in, because I'm telling you, I know for a fact that it ain't me.
Okay.
Every day I'm going to sue,
Okay.
because, and then it's going to add up, because this ain't right.
Okay, so I'm setting a hearing on September 9th at
I ain't
8:30
going.
and September 11th at
I'm
8:30.
not going.
Both in the downtown Maricopa County Superior Court.
I'm not going. I'm
I am
laying
setting
my
a
bed.
secured appearance bond in your matter in the amount of $100. All right, sir, go ahead, step to left. Officers have your paperwork for you.
So Eileen had a good question.
Hey,
She was asking about if female judges put up with more lip than male judges. There's got to be a certain percentage of it. There's got to be there's that group of guys that don't respect women in authority, and then there's other guys that think they can talk a woman down or overpower her. But in the end, some of the people that come to these courts are just criminals. Some of these people that come to court have no manners, no sort of ethics. No, they've been doing this for years, so this is what they do. Talking with Kathy earlier, she hadn't seen the Judge Oakley clip from earlier this week. I've got about a handful of them. He did some good trials, but most of his trials are too long to get y'all's attention, so we'll just jump over to this little short clip of him.
Waiting for defense counsel.
All right.
Now, do we ready on Singleton?
Gentlemen, your appearance is on Singleton.
Thank you, Your Honor. Good morning. Steve Allen on behalf of the people.
And good morning to your honor, court staff, Jonathan Roberts, the 86428 on behalf of Mr. Singleton. Statement in the court.
Thank you. What do we got?
Your Honor, with your approval, defendant will plead guilty to 2 counts. They'll plead guilty to count 3, driving while license suspended. And also, the judge added count 4, added count 4 is a 1-year misdemeanor known as attempt, fleeing and eluding in the 4th degree, and that would be under the penal code, Judge.
All right. And Mr. Singleton, have you discussed your rights and options with counsel? You understand those rights and the options they present to you today? You understand the possible penalty for those 2 charges? Attempt and the drove while license suspended? Understanding all of that, are you pleading guilty to those charges? Are you doing so freely and voluntarily today? Are you doing so freely and voluntarily? All right, counsel, if you would voir dire, give me the facts I need. Incident date, August 23, counsel, if that's what you're looking for.
On that date and time, Mr. Singleton, were you in a motor vehicle? Were you driving that vehicle? At some point during that evening, did you encounter the police? And did the police flick their lights on to indicate that they were initiating a stop? And did you disregard those lights and continue driving down the road? At the time you were driving down the road, you did understand that those were police officers. Defense is satisfied.
All right. And at that time, was your license suspended, revoked, or denied, sir? I'll accept the plea to the added charge and dismiss original counts 1 and 2. Well, 3 was the charge, DWLS. So I'm inclined to send it for a pre-sentence investigation unless you guys try to talk me out of it.
This is the first offense that's gonna be under HIDA, I think, this court hasn't.
No objection to Heidick? Sorry to cut you off, counsel. All right, go ahead, counsel.
Super good, structured and downtown.
Mhm.
There shouldn't be any issues. Part of his conditions, I think, are they want to be that needs to get that license worked on. You can't drive until that license is,
Right, right.
up to speed. So to say, in terms of fines and costs, his family is here, has a lot of support.
Good.
First, last time they did.
No priors? Okay.
Your Honor, if I may,
Yeah, please.
especially recommend reporting probation, no jail, under the useful phase 6.
Thank you. Mr. Singleton, where'd you go to high school? Graduate? You're in your senior year?
This guy doesn't speak too loud, so the Judge Oakley has to pull the information out of him. But you can tell Judge Oakley's about to get started going into his way of doing things. So, but he's pulling the information out of him. He's going to make sure this kid comes along right.
What's your GPA? Yeah, and in 30 years on the bench, that means it's not nearly as high as it could be. Am I right? What are your plans post high school? Yeah, what do you plan on doing after high school? Okay. What do you have to do to get your driver's license straightened out? Has he ever had a license, counsel?
I think it's been tickets.
Okay,
I don't know what,
okay.
just the tickets to cover the
Right.
license.
Is that woman with the head bobbing back there, mom? Sister? I'm sorry to hear that. Can I hear from your sister? Because it sounds like she might know more about your business than you do. Is that all right? Ma'am, come on up. State your name for me. Miss Singleton, do you know the status of his license? Come on up here with a microphone so I can hear you better. You're all right, come on up. Because of too many points? Can you run it? Print it out? He got in enough to see me. That's too much. And that's too much. Yeah, his biggest trouble is because he can't tell me he's doing the best he can in school. I didn't make that kid. And the fact that you're a father is not going to make your life easier without an education. Keep talking off, bud. because I'm getting ready to send you. Keep talking. Keep flapping those jaws. Because you're telling me all I need to know about you right now.
So, Judge, you know, not having this data is like, we think it's wrong. There is a lot there.
Absolutely. And it all sucks. It all sucks. But every day this young man gets up and he gets to make his own choices today. And he's been making bad choices. Keep your dick in your pants. You wouldn't have a kid at 18 without a high school education. Tell me I'm wrong. Smart man, tell me I'm wrong.
Speaking of that language, I was trying to get a Judge O'Donnell clip for you tonight, Linus, but I'll have to get it next time.
Counsel, come on up. I can't let you have it, but I want you to look at it, because the way I'm reading that, it says he's eligible for restricted right now. But it's been years since I could read those, because they keep changing the format and they keep making them worse.
That's how we know we're getting old, everybody. When the lawyer's hair is like that,
Driving privileges.
we know we're
Would you
getting
agree or
old.
disagree?
That judge looks like a kid to me.
Effective from July. I don't know how long the suspension would last. I'm fine, I mean, as a condition, I would be fine with either saying he just cannot drive without a valid license, and that would kind of solve the issue.
Good.
Your Honor, may I address the court?
Yeah, please.
Thank you, Ron. If he's convicted of suspended license, as you all know.
It's gonna, Yeah.
Your permission, Judge, I would like to have a plea instead of reckless driving count 2. I think that would be more benign versus driving record.
I mean, that would have points.
it's gonna be 6 points versus 2. The DWLS is 2 points.
Judge, if I may, I would.
I'll tell you what, hold on. Let's get outside the box a little bit. If you want to be generous,
Yeah.
let him plead to allowing an unlicensed driver to operate, which is the same thing you'd give her if she let him drive when he was suspended, right?
I'll adopt that.
No points. All right, won't stop you from straightening his license out, and I'm gonna require that he get his license before he's off this HIDA, or I won't give him HIDA.
Thank you, Judge.
You understand that? So he just agreed to save you 2 points and another suspension period. Yes? When are you supposed to graduate? Mid-year or spring?
All right, so HIDA is a program in I know it's in Michigan. I'm not sure where else it's at. But basically, if you play by the rules for a certain amount of time, it comes off of your record and it doesn't show up as a felony on your record. It doesn't show up as a crime on your record. So if you play by the rules and you mess up once or twice and you get back on the right track, they end up taking it off your record. So it's a good deal as long as it's not abused. So here we go.
All right, Mr. Singleton, I'm going to do a 12-month delayed sentence under Holmes Youthful Trainee Act. I'm not going to assess any money. You will report to my probation department on a regular basis, and that could be by email. They'll work that out with you. I'm assuming you can give them transportation a couple times. All right, so as long as you're on track for the first month or two, they'll probably let you just do it on email. I'm gonna require that you get your driver's license straightened out before the 12 months is up. I'm gonna require that you get a high school diploma before the 12 months is up. And I'm also gonna order 30 hours of community service charity work. That means you volunteer with some nonprofit agency that's registered with the IRS. Church, soup kitchen, Salvation Army, Boys and Girls Club, I don't care. As long as it's an IRS recognized nonprofit, 30 hours, document those 30 hours, and I want that done between now and December 1, 2025. Do you have any questions about what you have to do to get the benefit of HIDA? All right, understand, I'm still holding jail time over your head. Make my tail wag, or you probably will go to jail. Do you understand that? All right, now, I have to say this or I will not sleep tonight. Dude, I am glad I didn't have your problems as a kid. But with respect, with sympathy, I want you to hear what I'm about to tell you. The world does not give a shit if your life sucks till you're dead because of the problems you had in your youth. The world doesn't care. Okay? If I had a magic wand, I would tap you on the head and give you a perfect childhood. I can't do that, but I can tell you what I know after 40 years in this business. Dude, you got to make your own future. Your past does not define your future. Your past sucks. I hear it. All right, I'm sympathetic, but man up. Every morning you get up and make good decisions. You work hard. You sacrifice now so you don't have to sacrifice when you're 50 and 60. Because if you don't start doing things better, you know what you're doing? Your child is going to have the struggles you've had. You want the boy or girl? Girl, you want that for your little girl? Hell no. Quit focusing on the past, the things that didn't happen the way they should have, and seize the future, man. All right, I'll sleep tonight. Anything else, counsel? All right, he needs to go down to probation. Sister, thank you. You're welcome, counsel.
We have several other things in the way.
Well, I love the way Judge Oakley talks to people, but also love the way he brings in the sister, brings in the mother, brings in the family member, because he knows that whatever he's saying to that defendant, they're not listening, that everything's going over their head. So you bring in somebody that's a little more sane, got a little more sense to them to beat it into them later. You know, you're not supposed to hit them, but sometimes you have to hit brothers and sisters, right? So I was supposed to give an update. Grandkids doing great. My 17-year-old daughter's doing great. My 26-year-old daughter's doing perfect. Emily's great. Everything seems to be good. We're going to jump over to People in Court. She did a video. I did watch it. I'm just don't remember what it is, but it was certainly a good video.
This is the stuff out of a movie. This is what makes people have nightmares.
All right, Judge Uraquel West out of Beaumont, Texas. So I think she's in the same courtroom as Judge Stevens. She does a good job. She gives them hell, and that's what we're looking for. So let's see.
Mirrors at night, and you instigated it.
Go watch People in Court. She does good videos and all that stuff.
Cause number 38631.
I'll go ahead and pause it real quick. A lot of the comments are going to block the comments she puts on there. So I'll move some stuff down over this way. So we'll try to stay out of her way. But she adds a lot more commentary than I do. She thinks a lot more than I do. So we're going to look for her to add some commentary to it. So here we go with this.
Your Honor, I'll wait for my client, but he's informed me that he wants to withdraw his plea.
Yeah, I already know that. All right, sir, you Devin McGee? And Mr. McGee was previously in court, entered a plea of guilty to the first-degree felony offense of burglary of a habitation with the intent to commit aggravated assault. And that was, the agreement was for a cap of 30 years in the institutional division of the Texas Department of Corrections. I have received a pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
I have. I've also received, it looks like a letter from Mr. McGee that I have taken notice of, as well as a couple of, looks like some incident reports from the jail. Have you all had an opportunity to review those?
Yes, Your Honor.
I have. Are there any additions or corrections to that pre-sentence report?
Your Honor, the only additions that I would have is that I've received 2 letters from family members. I'd like to have the court have access to that before making a decision. However, I'd like to read from some of the letters as part of my closing. So I'd like to hold on to them, but then I would like to present them to the court. They're written by 2 close family members. And then further, the only other correction in the pre-sentence report, I guess we need clarification. While the defendant was previously in court and pled guilty, he's informed me this morning that he wishes to withdraw his plea. I let him know that that was up to the court. That's not up to me.
So, Mr. McGee, when you were here before, you were sworn in by the clerk and asked you some very specific questions about your plea and whether or not you were doing it freely and voluntarily, whether or not you did it because you actually did what they charged you with. Obviously, you know that I sat through the trial of your brother, so I've seen all of the evidence against you that would be presented at trial, the videos, all of the things. And so I guess I'm not inclined to let you withdraw your plea. I want to know, though, quickly why you think you want to.
I don't want to withdraw my plea because I was informed, well, I found out that I can't get probation on this, and I thought I could.
And that's not correct, Your Honor. He is eligible for probation.
You are eligible for probation.
And I have told him,
Affirmative finding of a weapon, I couldn't get it.
What?
Affirmative finding of a weapon, I couldn't get it.
If I make that finding, I can give you anything right now from a deferred probation up to 30 years in prison. That's the range of punishment. So you are eligible for probation. That is an option that I have. So that's whoever has told you that, you're misinformed. That is an option. All right. So I am not going to allow you to withdraw your plea. We're going to go forward with sentencing. Mr. Nix, you may proceed.
thank you, Your Honor. Your Honor, in reviewing the PSI, obviously the court's seen some of the evidence. It's not good evidence. But the one thing that I think needs to go in Mr. McGee's favor, obviously, is that he did take responsibility. He did plead. Obviously, he's gotten some bad legal information in the jail since we were last here in court. But that shouldn't change the fact that Mr. McGee has had no criminal history other than some traffic citations and a few failures to appear on those traffic citations before this. He's never been in our system. He's never been on probation before. Never been sentenced to prison before because he has no criminal history. Mr. McGee did not live the same life that many of us have lived. One of the letters that I received from a close friend, they've known Devin since 2017, so approximately 6 years. Not only did they speak very highly about how Devin would typically put himself before others, and he had a very rough childhood. His mother passed away in front of him at the age of 27. They had no father figure. They were tossed and moved around with their 3 aunts from 2007 to 2017. They both suffered physical, mental, and verbal abuse from 2 of their aunts. Mr. McGee also has a 3-year-old child. He's never really stood much of a chance. He's never had a positive male figure in his life. And that's not my words. Those are the words of close friends and family members that have kind of written on his behalf. They were completely shocked and said that this was out of character for him to partake in this crime. They believed that he was following his brother. They said that this is not who Devin is. Obviously, the court has just what it has in front of them, which is the evidence from that case. And if you just look at the evidence in that case, obviously it's going to give you pause because of the nature of and the violence that took place in the offense. While my client understands the law of parties and he knows that he's just as responsible for whatever his brother did that day, I will say that he was not the aggressor or the main aggressor in the situation. The crime that they committed was despicable, and he would agree with that. He thought that he was going over there to retrieve stolen property. He did not know that his brother was going to start shooting. And in visiting with Mr. McGee, I believe he was also a little afraid and didn't know what to do in the situation once it started going further and beyond what he thought it was going to be. Further, Mr. McGee has told me that he has found religion. He has, one of his write-ups has been because they did not warn the jailer when they were going to pray. So that was one of the write-ups that he had. He also had a jumper malfunction with his buttons. But he says that his newfound religion has given him discipline and peace in his life. He has a son now. He apparently did not know about that. I believe he became aware of that while he was incarcerated. The child was 3 years old. And he would like to have some sort of a life with a son. I would suggest that he get 10 years deferred adjudication probation. And if he messes up even one iota, he's got the full range to deal with. So I would suggest that he get 10 years deferred probation, be put on intensive supervision, 0 tolerance, and actually be given a chance, because based on his criminal history, this is not who he is. This is not, and I hope the court doesn't take into account the fact that he tried to withdraw his plea today. I think he got some bad
No, I'm
information.
not worried about that.
Yeah, he got some bad information in the jail, but he is eligible for probation. I would ask that he get probation. And I'd give Mr. McGee a chance to address the court and explain why he should get probation.
I would love to hear this.
First and foremost, I would like to apologize to the victims in my case. I didn't know, like my lawyer said, I didn't know that my brother was going to go over and shoot him. He told me.
Hang on a second, Devin. Just stop. All right. Y'all went over there with a gun. Hang on. I've watched the video.
Mhm.
And you were the one who egged your brother on the entire time. I'm not even sure that your brother would have done what he did had you not been there. Just in his face, do it, do it, do it. I've seen it. Hang on. I've seen it. There's probably nothing you can say right now that's going to help anything, because all you're doing is trying to not take responsibility instead of taking responsibility. Ms. Malfino.
Thank you, Judge. You just took the words right out of my mouth.
Sorry.
You were having no criminal history. We saw him go from 0 to 100 in a matter of 2 hours that afternoon. On behalf of the Jones family, we appreciate the court taking the time when we addressed Tevin's case to carefully consider all of that evidence. This is a unique situation where I don't even feel like I need to argue the PSI. You have everything in front of you. I know you recall it. I know you remember it. I know you know the violence there, and he was responsible for those actions. He needs to be held responsible. I appreciate Mr. Nick's argument. I respect him immensely as a professional. He's just doing his job. The words probation are just absolutely ludicrous for this case. I think Jason said it best when he told you this is not a gift to Devin. This is a gift to them, to let this be over, to stop the nightmare. They deserve to have some peace from this. Your brother's gone for the rest of his life. You better be glad that your exposure is 30 years. And that's not a gift to you. That's by the graciousness of this family. Judge, on their behalf, I would respectfully ask 30 years with them for what I am Devin.
Your Honor, can I present the 2 letters?
So, I mean, I appreciate Mr. Nick's argument. I appreciate these letters. The problem with these letters is I don't know. I wish if they hadn't seen that the people who are saying what a good person you are and how much remorse you supposedly have, and that you've taken responsibility, saw the video of what happened that night. There's not a whole lot of times here in court that with cases, we have the opportunity to have pretty much every single part of an offense on video, right? And That makes this unique. It's unfortunate probably in some cases that we don't, because probably other people who've done similar things get maybe some breaks that they shouldn't, because we don't have all of that. What you and your brother put that family through that night is the stuff, and I think I've said this before, the family's probably heard me, I know, tell your brother this. This is the stuff out of a movie. This is what makes people have nightmares at night. And you instigated it. You walked with your brother with that assault gun, however far y'all had to walk, knowing you weren't just going to get property holding a gun. Well, you can object whatever you want, but I know what I saw. I know that you instigated him to keep doing it. You showed him how to take the safety off the gun. I remember all of that. So at this time, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. And at this time, I'm going to find you guilty of burglary of a habitation with intent to commit aggravated assault. I'm going to sentence you to a term of 30 years in the institutional division of the Texas Department of Corrections. I am making an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification, Mr. Nix, that shows this was an agreement. So you have waived any right to appeal. You've also been handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. You should thank Mr. Nix. He did an excellent job for you, limiting your exposure, and on behalf of the family, to give you that opportunity to have it limited at 30 years. You're very lucky, and I hope you take advantage of this. When you get out, you're still going to be young and have an opportunity to live a life, and you can choose. I hope you really have found religion and that you keep that, and that when you get out, you prove yourself that you're not that type of person. All right, good luck to you. You can go back with the bailiff. Yes, hang on. Absolutely, hang on. Can y'all clear the table so he can have a seat? They're going to do a victim impact statement.
Devin McGee, October the 8th, 2021 is a date that me and my family will never forget. You and your brother attempted to kill my husband, Jason. You and your brother tried to kill our innocent little dog as you entered our house. Prior to entering the home, the same very home that Jason and I built for our family, that we raised our family in, raised our children in, and it also became the home of our grandson, your nephew. You both taunted us for what felt like a lifetime. I will never forget the sounds of bullets spraying through our home. I will never forget the visual of seeing my love, my soulmate, my husband, the father of my children, the grandfather of my grandchildren, slumped down in a bathtub filled with blood, glass shattered everywhere. The sight of spent casings and shattered glass, spent casings that kept being discovered long after the crime was committed. You two had one goal in mind that night, and you both know that is correct. The goal that you both had was to kill every one of us in the home that night. And I'm here to tell you, look at me. I'm here to tell you failed. You are worthless. We have a very small fraction of our many supporters that are here today to see justice through, that we're here to see justice through on your brother as well. Our lives are forever changed. They'll never be the same. But one thing that we can take pride in and knowing and going forward in is that justice is served. Justice is never fully served to the victims, as this is something that we have to go forward with ourselves and deal with on our own behalf. There's nothing that no one can fix. I hope that you are filled with fear every single second of your life. I hope that every time you close your eyes at night, You see my face, you see my husband's face. We are survivors of the crime that you and your brother purposely committed that night. And I'm here to tell you, don't ever mess with the Lord's creations. On behalf of my husband and I, and on behalf of our family and friends, we want to give our immense gratitude and sincerest appreciation to Port Neches Police Department, Nederland Police Department, Groves Police Department, Port Neches Fire Department, all medics involved, Jefferson County District Attorney's Office, Philip Smith, Ashley Malfino, investigators Troy Robinson and Brandon Crowder, Port Neches Police Department Detective Scott Thompson, Christie St. Elizabeth Trauma Physicians, and last but not least, to you, Honorable Judge Raquel West, thank you for all your support.
Good luck to all of y'all. Thank you all. You can go back with the bailiff.
All right, that was kind of deep there at the end. I love the victim impact statements. They kind of remind you that this is human. You know, the guy that's going away for 30 years. I'll be honest, I feel bad for him. He was stupid and made a mistake, and devastated someone's world, and he's got to pay the price for that mistake. He found Jesus, he found God, he found religion. Good. I'm almost certain that all Christian teachings say that you've got to be responsible for your actions. And so spend that 30 years continuing to grow and continuing to be good. And whenever you get out, when you're, hell, I don't know how old he was. He looked like he was maybe 20. So whenever he gets out, he's 40 or 50, maybe he'll be a better person. But I doubt it. But I don't know. But I hate when people magically find religion in jail and think that that's going to get them a shorter sentence. All right, here's Judge Simpson. This guy likes to drink. Here we go.
Assistant Public Defender Ben Dunlap on behalf of Mr. Barnhart, who stands to my right. Would you state your name for the record, please?
Philip Barnhart. What are we doing?
Your Honor, Mr. Barnhart is prepared to waive his exams. I think there may be another issue that the APA wants to bring up, though.
Report and receipt of the bond violation report from Community Corrections.
I have a report dated September 10th, the progress report, yes.
Yes, Your Honor, and I understand that the defendant was released from jail on September the 2nd, went to Community Corrections to test on September.
All right, I'm going to go ahead and knock that one out. Yes, he made a choice and made a mistake. I've made many of choices that were mistakes. And so I hate Judge Boyd playing the damn word games, and I hate anyone else playing the word games. There's plenty of people out there that are products of mistakes. There's plenty of people that are making mistakes and having kids every day. So there's plenty of mistakes that are choices. So, Kathy wants to stream 5 times a day. That's a choice, and I think it's a mistake. So it can be both a choice and a mistake at the same time. If Judge Boyd don't like it, she needs to call me and talk to me about it. I'll take her call.
The 3rd, and when he tested on September the 3rd, he tested positive for cocaine, THC, benzodiazepines, and Suboxone. I understand also that this was his first test, so there is an argument that he may not have been on bond at the time that these substances were consumed, therefore it may not be a bond violation. However, I did double check ex-jail, and he was booked on August 31st and released on September the 2nd. So there were 3 days in custody. So it's possible that certainly the THC could have been from before. The cocaine, I'm less certain of, with extremely heavy use, maybe 96 hours on cocaine, but no matter what, these are OWIs at least 4 and 5, and there's another pending OWI in Wayne County. I'm very concerned that he is not able to control his substance use and is a danger to the community.
Your Honor, I believe there's a window that would make this not a bond violation. I think if he would have used on August 30th or the 31st.
But if this is a 5 and this is showing up in his system at all, I would consider him a danger to the public and that his bond is inappropriately set. So I'll let you make your argument, but.
Can I have just a second, Your Honor?
Sure.
So, yeah, I just think there's possibilities that he's not used after being arrested, and those.
Yeah, what?
I mean, cocaine could stay in his system for up to a week if there's heavy use. So the failure,
Let's say, well, I don't know, a week, but let's say I agree with you regarding that. Then his bond, and this is what I'm saying to you, then his bond on these operating while intoxicated, since I have two in front of me and there's another one in Wayne County, then I think that his bond in these cases is inappropriately set. And what I mean by that is that I clearly have these two cases. There's the other one in Wayne County. He's got priors and he's still using.
I think I'm fine. I think that's all factually true, Your Honor. Or he's at least not passing the test. Would the court be willing to have him test today?
Would he come back clean?
Yes, sir.
But here's again my problem, counsel. My problem is really the danger to the community. Because I have an incident that occurred in February of 23. This other one occurred in July of 2023 or 23. He's got a pending Wayne County one. He's got prior ones and he's still using. So I don't know that he should be out because at some point luck's going to run out. He's going to get behind the wheel and he's going to take somebody out. I don't have a vehicle.
Your Honor, I don't believe he's driving. The test certainly indicates use. Look, drunk driving is absolutely dangerous, but there's no dispute. I think if he's using drugs in his own home, I don't believe that's a danger to the community that rises to the level of him needing to be incarcerated. I think he can remain out if he fails a test. That would be a bond violation at this point because he has been on bond since, I think that would be the 29th, 28th or 29th. So if he fails the test at this point, that would conclusively prove use while on bond. And I think absolutely the court at that point would have undeniable jurisdiction to revoke his bond. I would say that I don't believe the information in front of the court at this point proves he's actually a danger to the community.
So you're arguing to me that with all, this is legitimately 4 and 5 with another one pending in Wayne County and he's still using, you're saying it doesn't show to me that he's a danger to the community?
I think if he was driving, I wouldn't absolutely not even argue that, no question. I think him failing those tests, and we don't have a pattern or anything like that. We don't know if this is a one-time slip up. We don't know if he's used while he was on bond. I think the court could allow him to test today, and that would solve the problem.
May I respond?
Right.
I would wholeheartedly disagree that there's no pattern. I think that the defendant having 3 previous convictions for OWI in 2002, 2004, and 2016, a 2023 Wayne County case, a 2023 Washtenaw County case, and a 2024 Washtenaw County case is absolutely a pattern. Furthermore, Your Honor, in this matter, if I recall correctly, and I think I do, but I will make sure, I believe his BAC was incredibly high. And I'm going to double check that before I make that search to the court. But if I recall correctly, I think in
0.30 and
both
higher.
cases, his blood alcohol content was above a 0.3.
That's correct, Your Honor.
So we are not, if this isn't a pattern, I don't know what a pattern is. People would request that the court find that the bond was an abuse of discretion and set a higher bond and remand.
I just don't think the circumstances have changed since the bond was set because and I know the court could disagree, but we don't believe there's evidence he's used since the bond was set by the magistrate, at least conclusive evidence. It's up in the air as far as he failed the test.
You keep arguing the use. The argument is, even if I give you that, the argument is I don't know that he should be out. Any use, given his record, and he's out on basically a PR, I think is an abuse of discretion. Now, if you want to argue that with me, certainly I will hear you.
Okay. I think it would not be abuse of discretion because of the length of time that has passed. So, we're already into August 2025. The positive test, we can't really deny it, but what we can say is he's not driving a car. So the extreme danger to the community that comes with intoxicated driving is not present. Obviously, there's some danger to the community in hard drug use, but I believe it's less. I believe it can be managed with restrictions such as continued testing. If he fails again, he's obviously used while on bond. The court could do that. I think the court could order increased testing. You could put him on 3 times a week. I think he was on 1 time a week. I mean, the court could order testing every day if the court felt that necessary. There's a lot of options other than just incarcerating him.
What did you wish these set for?
I'm sorry?
What did you wish these set for? Preliminary examination?
No, he's going to waive.
He's waiving? All right. So at this point, what I will do is his bond is going to be changed. I'm going to set it at $25,000 cash or surety. Sir, you're waiving your right to preliminary examination in these cases? Sir. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them? Yes, sir. You understand you will not have that hearing on either one of these matters, and that this will proceed to circuit court for further resolution? Sir. People also waive their right?
We waive, Your Honor. I do believe he previously posted $25,000.
Oh, are on both of these?
I think that's what my notes reflect, is that that's what it was set at.
I mean, I thought they were PRs.
It might have been PRs, and $25,000 PRs, but
I have each of these that they're PR.
Oh, I apologize, Your Honor. My mistake. Thank you.
So people do waive.
We do.
Preliminary examination haven't been waived. Defendants bound over to circuit court on a single count in each case.
We will stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute, court will enter not guilty plea pre-trial. Custody pre-trial date.
September 24th at 1:30 with good time.
September 24th, 2025, 1:30 before Judge Conlon in each of these matters. The bond, as indicated, is set in each case. It will be changed from a personal recognizance to a $25,000 cash or surety. Defendant is remanded.
Okay.
Yes, you may. What was that date again?
24th, Your Honor.
I had to get at least one mute in there, damn it. That guy was really odd, really close to that camera. Thank you guys for coming out. Thank you guys for doing, hold on a second. Thank you, Kathy, and thank you, Jennifer, for the super chats. Those are always fun. And everything's good. Jen, Kathy used your card, so that works out. Yeah, see, it's neat on the thing that I'm using, on the software that I'm using. I don't see those stupid crowns, and so I don't worry about any of that. Yeah, I pulled a Kathy. So, all right. Well, I'm going to get out of here. Thank you so much. I'm going to try to do one tomorrow. We may be able to pull one out tomorrow. I'm going to try my best. I never know what the world brings me. I never know what work's going to do. So we will do that, and we'll throw this on for the fun one.
No, I'm totally fine. Like, love it, love it, love it. Can I ask why?